one of the highlights of the LMH calendar. This is the 30th Howard Smith lecture, which is just a fantastic celebration of legal scholarship and practice here at the college. So grateful to Don and Suzelle for supporting this lecture and supporting the college over so many years. Also delighted this is a rich audience of legal expertise. Of rich legal expertise. An audience of rich legal expertise. Great, and I'm delighted that we have Lord Banks from the Supreme Court, Lady Arden from the Supreme Court, and Justice Hogan from the Irish Supreme Court. We also have the most important lawyer in town, which is the Dean of LMH, David Campbell, our tutorial fellow, who is the #1 litigator in Oxford. And I'm also delighted to welcome some of our students, and I just want to mention that one of our students was on the Jessup Moot team, the Oxford team, that won the UK national title.
Wow.
Bravo.
Wow.
Went to DC, made it a long way, finished 5th internationally, and I just want to, as a reflection of the vibrancy and richness of the legal activity here in the college. We're just delighted to celebrate it at this event. As well as the intellectual richness, Don and Suzelle have been long-time supporters of the college. So grateful for them and what they've enabled here at LMH. And also grateful for the counsel they have provided to both me and Fiona and our predecessors. And I think it's testament to their commitment and engagement in college that I'm delighted to welcome back my predecessors, Alan Ruskia and Lindsay Mackey, Francis Lannon and Gillian Peel will be here very shortly, and Sir Brian and Lady Paul. It's a really amazing occasion and a privilege for me as principal to welcome Don and Suzelle and have my predecessors here. And I just want to say on a personal note to my predecessors, thank you for your counsel and advice, and I'm honoured to be head of this college. Don and Suzelle obviously have been extremely successful and in their careers. As I look back and try and source where that success comes from, I'm sure they'll have slightly different views than me on this, but the thing about Suzelle, obviously that came from her time here at LMH, but in particular being one of the first students in the tutorial with Gillian Peel. The first year that Julian Peel was a tutorial fellow. Hey, oh yeah, hey. And I just think, would you have thought in your first year as a tutorial fellow here, the influence you had on your students, and in particular the impact that your students had in the years ahead? So it's tremendous. And just on a personal note, I just want to mention my stepson, Tom Bialetti, Fiona's son, was one of the last students you had in tutorial in 2016. So it's a lovely bookend personally for us. So it's great to have you. When I think about Don, obviously Don has 3 Harvard degrees, none of which I have. But his legal expertise was certainly based on being Harvard classmates with a US Senator, Al Gore, a US Marshal, Tommy Lee Jones, and Churchill, John Lithgow. But you also just missed the Unabomber, so that was probably beneficial for your career. Anyway, it's a pleasure to have you here. Thank you, Suzelle and Don. We're not just the 30th Howard Smith Law Lecture today. deeper we search, the more we find there is to know. And as long as human life exists, I believe it will always be so. Which I think is a fantastic representation of what we as a college at LMH are trying to enable our students and fellows to search deeper and to discover there's more to find out. We're so grateful for the support of our alumni to enable us to do this, and also to reflect and represent that. And I think Don and Suzelle, in terms of searching deeper, discovering there's more to know, are great incarnations of that. So thank you again for being here. Thank you, Don. So I'll hand over you to the lecture, and look forward to seeing everybody in drinks and dinner afterwards. Thank you.
Thank you very much. I was enjoying thoroughly that introduction until he came to the part about Albert Einstein, and then I could only reflect on the profound decline of the discourse in the college over 90 years. One has an image of the curvature like this, of space and time. But thank you so much, and it's a pleasure to be here. Tonight, we may leave you, unlike Einstein, remembering some of it. I hope we won't leave you confused, but if we do, maybe you'll be confused at a little higher level than when we started, we hope. But tonight we're going to talk about our experiences with the Vatican and commercial litigation. And particularly, we're going to emphasize tonight not only the legal aspects, the contractual issues, which are, as you students who are called to the bar will be experts in these, but the principle that when you master those and get called to the bar, you then have the opportunity, a license really, to meet with exceptional people, to explore real-life dramas and areas of expertise that you don't learn about in law school, but you will learn about thoroughly in your practice. And so tonight, we're not only going to talk about the legal contractual issues briefly, but the client relationships, the Vatican operations, and the issues in this case, the one we'll be talking about tonight, relating to reproduction of art. And the experts you heard about somewhat if you came last year, because we have two of our past experts here. Sir Peter Bottomley, who was here, was the expert in the Suzuki Samurai litigation. And we have two-time Emmy winner, Court Cassidy, who's sitting here in the second row, who was our expert in the Olivia de Havilland litigation on rights to your name and property as a property and interest in Hollywood. The court, by the way, also wrote and performed one of my two favorite songs of all time, entitled, "Didn't You Always Dream of Living in Malibu?" You can't make this up, he did that. By the way, my other favorite song also comes from Malibu. Dr. John Zambetti is with us tonight, and he wrote and performed a song called "The Call of the Wave" for a movie, Step Into Liquid, my other favorite song. So we're very glad to have experts here tonight, and we'll talk a little about experts. But I want to refer you to experts, to that great legal scholar and that standard compendium of legal resources, Sir Arthur Conan Doyle, whose book, The Hound of the Baskervilles, I'm sure is on everyone's reading list here. But I think he nailed it exactly right. He says the barrister, or if you were in the United States, it would be the trial lawyer, who has his case at his fingertips, is able to argue with an expert on his own subject. That is, for that moment in time, he's understood enough and worked with his expert so that he can argue with the opposing expert on cross-examination at that right level. And I think he's also right that within a week or two in the courts, he's forgotten it and gone on as if nothing had happened. But I know that tonight you expected the premium seats, and so for that, I'm going to call on my life and law partner, Suzelle Smith, to get us started.
So just a moment to talk about personal bookends. So Gillian Peele was indeed my moral supervisor. There used to be things called moral supervisors at the Oxford colleges, and Gillian likes to say that my morals are a reflection of her tutorage, so you can take that. She also taught our son Ames, who was PPE student at LMH, and he's here tonight. So Jillian, we've known and loved for many, many years. We've been here long enough, 30 years, giving lectures at Oxford and LMH, that we've been very good professional and personal friends with Brian Fall and Del Mar, and with Alan and Lindsay, and now with Stephen and Fiona. So we're thrilled to be here once again with all of you. Many of you in the audience are either former or current Howarth and Smith clients. And so the title of our talk tonight is Angels and Demons, representing the Vatican in commercial litigation. And we are going to talk about some aspects of representing the Vatican that may make you a little nervous, because you may be thinking, well, Dawn and Suzelle are spilling all these secrets. Are they going to do the same thing about the confidences that you have given us in the course of representation? And so I want to assure you that everything that we are going to talk about tonight, and you can draw your own conclusions about who the angels and the demons are. We're not actually going to point to them and put horns or wings on them. You can draw your own conclusions. But everything we're going to talk about tonight is a matter of the public record, either in the court transcripts or there was press that followed this case, particularly in the New Yorker magazine. And so we'll be referring to aspects of the litigation that were published. So relax. You're still under good attorney-client privilege. The case, the 1990 case for the Vatican, that was the first matter that Dawn and I, Howarth and Smith, handled for the Vatican, involved intellectual property and the licensing of intellectual property, artwork, manuscripts, designs that were owned by the Vatican and the Vatican Library. The contract, which was at issue, this was a breach of contract case that was brought by Southern California businessmen who entered into a contract with the Vatican to license artwork, and it was about a $100 million deal. And back in 1990, $100 million still was some significant money. So we're going to talk about the contract, what happened with the contract, what the claim for breach was, what the defense of the Vatican was, as we go along tonight. I know most of you know the Vatican. You've probably been to Rome. You've probably visited the Vatican. But just as a little setup to remind everyone, the Vatican is its own sovereign state. It's not only a church, but it's a sovereign state. The head of the Vatican state is the Pope, or the Pontiff, who is really the last absolute monarch who claims to be an absolute monarch. The Pope is in legal complete control of the Vatican. Now there, the details of administration stop. The clarity stops. Once you get below the Pope, there are administrative units in the Vatican, but it is pretty much obscure who reports to whom and who controls what, whether by design or accident. You can't look at it like you could the British government or the United States and get out your textbooks if you were studying for your exams and try to figure out where the lines of power actually go. It's opaque. So the government of the Vatican City, though, just for purposes of our discussion tonight, there is the Roman Curia, which is administrative units underneath the Pope, and some examples of those are the papal household, which take care of the Pope, including everything from his dressing to his schedule and helping the Pope do his duties. The Swiss Guard is another administrative unit. And the Vatican Library, which was the actual administrative entity. It's a separate governmental entity, and the Vatican Library was our actual client, the unit of the Vatican Library. You may not have heard of the Vatican Library. Some of you probably have, but it was established in 1475. It's a very important international library. Pope Sixtus established it. The property in the library is not just the manuscripts. There's artwork, there's sculptures, there are coins. There are a lot of things that are actually owned by the Vatican Library. And the prefect of the library is the chief administrative officer. That's the person who runs the library, controls the staff, dictates what happens in the library, and runs the whole operation. In the Vatican Library, in the collection are manuscripts, scrolls, books, ancient goatskin writings, coins, paintings, sculpture, furniture, jewelry. It's not just books in the library, and it controls billions of dollars of art and manuscripts. Some of the more famous items in the Vatican Library, the oldest copy of the Aeneid in existence is in the Vatican Library, and I know one of all of our favorites for bedtime reading, Euclid's Elements, book number 1, which of course explains the Pythagorean theorem, is one of the books that's in the Vatican Library. The artworks not just include the sculptures and the paintings, but the building itself. They have a Sistine Hall, which of their own, which has amazing frescoes on it. And so the collective artwork that's owned by the Vatican Library is immense and very, very valuable. At the time we were hired, the prefect of the Vatican Library was Father Leonard Boyle. He became our client. He was the person at the Vatican that we dealt with. He was from the Dominican order, and he had an Oxford connection. He went to St. Catherine's College and did his PhD in paleography and ancient manuscripts. He was a recognized scholar before he came to the Vatican Library, an expert primarily in illuminated manuscripts, also a bit of a detective. Don mentioned Sir Conan Doyle and Sherlock Holmes. He would go back and he could tell from writings and the form of writings when manuscripts had been, when they had been created, and he was a detective. He was the first Irish prefect of the Vatican Library and was appointed by Pope John Paul II. I emphasize the Irish because it was very good for us because we spoke the same language, sort of, Irish and English. But as many of you probably know, the Vatican has largely been controlled by Italians. Whatever the legal structure is, the Italians have had largely control of the Vatican since forever. And that was true at the time. We represented the library, and Father Boyle, being an Irishman, was a bit of a fish out of water, and some of the things we're going to talk about tonight, his Irish heritage explains some of it. I talked about the New Yorker, and there was a writer, excuse me, let me go back. There was a writer who writes for the New Yorker. He's been writing for the New Yorker for decades, Alexander Stilla, and he went to Yale, he went to Columbia School of Journalism, but he's written many books. Several books of his were on fascism, Italy, the mafia, and the Vatican. Is there a connection, you might ask? Well, you have to read some of Stilla's works. But he got very interested in the Vatican Library, and so he was doing articles about the Vatican Library before our lawsuit was filed. And then when our lawsuit was filed, he got very interested in the dynamics of the lawsuit and went behind the scenes to find out some of the things that were going on that were not in the court documents. So I'm going to be referring to Mr. Stilla for some of the actually more salient parts of the story, which he discovered himself. The library status in 1998 is important to the story because Father Boyle came on, he was appointed prefect, and he arrived on the scene, and the Vatican Library was essentially the way it was in the Dark Ages. They had lights, but just barely. There was no air conditioning. It was a very dark and ancient place. And Father Boyle was not a businessman. He was an academic. He faced as many Oxford colleges do, funding problems. He arrived at the library, and the entire budget for the library was about $500,000. To give you just a comparison, about the same time, the Bodley Library's budget was about $8,900,000 a year. And the Vatican Library has some of the most important works in the world. There was no proper cataloging. Everything was on little pieces of paper, and they weren't very well organized. There was no computer list of what was in the Vatican Library. There was no air conditioning, as I said, so it made it a difficult place in the summer to go into the library and to do the scholars to do their work. Father Boyle had a vision when he came to the Vatican Library. He wanted to modernize, itemize, digitize. He wanted to have internet access in the library. He wanted to increase the staff. He wanted student scholarships so that students could come to Rome and study in the library. He wanted to open the library to the wider public. The Vatican is a pretty closed place. It's its own state. To get into the, you can go into St. Peter's, but if you want to go virtually any other place in the Vatican, you have to go through the Swiss Guard with your passport, and you have to be admitted. It's a sovereign country, after all. He wanted to open the library so that ordinary people or ordinary scholars could come in. It was very difficult to get into the library in order to do research or look at the manuscripts. He also wanted to open a museum shop, which many of the other museums in the world had been doing in order to generate revenues for museums like the Metropolitan Museum in New York. And he wanted to do structural improvements. There were just things that were falling apart all over the place. There were frescoes that needed repair. There were beams that were falling down, and Father Boyle wanted to bring it up into the 20th century. So in 1988, some Southern California businessmen came to Rome, and they had a proposal to do a deal with the Vatican Library. They wanted the right to reproduce or sell all of the art objects, reproductions of the art objects or designs in the Vatican. Father Boyle inherited this introduction to the Southern California businessmen from an Italian cardinal named Stickler, and he had a PhD in canon law, which will become more important as we go on, about the lawsuit which was filed in Los Angeles under California law, not in Rome under canon law. But try telling that to an Italian cardinal. The US lawyers for the Southern California business people drafted the agreement for the Vatican and the Southern California business contract, and the Vatican, Father Boyle, again unsophisticated, had an Italian notary look over the agreement. Italian notaries are not lawyers in the sense that any of us in this room know them. They are more like notarizing documents. So the Vatican really went into this contract without the benefit of professional legal advice. But the deal was that these businessmen were going to pay the Vatican $4.5 million non-refundable. You get $4.5 million, which sounded like a heck of a lot to Father Boyle, who had a $500,000 budget, and he was going to be able to make many of the improvements that he wanted to make in the library. Plus, once the reproduction and the sale of the objects got going, then the Vatican was to get 40% of the profits without having to do any of the work on the business deal. This agreement, the contract between the Vatican and the Southern California businessmen, had a clause on jurisdiction, which is why the canon law becomes important. Any dispute between the parties, it was agreed that the jurisdiction would be in the courts of California. And that's the same. There's been a case in Britain involving the Vatican where the contract also had a jurisdictional clause. So when the Vatican tries to fight jurisdiction or contest jurisdiction, the courts in the United States have said, as did the court in California, the contract gives, you've conceded jurisdiction in California, and the same thing was true in England when a similar case arose. The the contract was very valuable to the Southern California business people, and they recognized that that was so because it gave an exclusive right to the Southern California businessmen to reproduce and market the designs, the reproductions of sculptures, and it would also have the Vatican seal of approval. So sort of like, you know, appointment to the Queen or the King, the Vatican was going to say, these items are exclusively approved and produced and authentic, Vatican approved. And the publicity value of having the Vatican name attached to the items and objects was very significant and very valuable. The idea was that these objects that would be produced wouldn't just be, you know, pietà that you buy on the street, but it would be high-end fabrics, china, furniture, and jewelry. And I'm showing a piece of jewelry which Father Boyle actually gave to me. It's a necklace, and it's a design from the Barberini bee. The Barberini family gave a lot of manuscripts to the Vatican Library, and the Barberini bee is the symbol of the family. And so he gave me this very beautiful gold necklace, which was one of the items that was produced and for sale. So things were going along, and the contract was moving along, but things in the Vatican move slower than they do even in Oxford. So we measure in centuries, not in months. And in California, we're used to a quicker pace. So the investors got impatient. The objects were being reproduced, but the investors got impatient, and they were really looking for a way to get out of the deal. It wasn't reaping the kind of profits they had expected as fast as they had hoped that they would be, incurred. So the basis of the breach of contract suit, which the Southern California businessmen brought against the Vatican, was that the contract which said the Vatican would use its best efforts to enable these people to make the reproductions, they interpreted that to mean that they could physically handle the items in the Vatican. They could remove items from the library in order to make the reproductions, and they could do things like make wax molds of actual sculptures and coins. So that was their position. It's an interpretation of best efforts. They said this would be the best efforts. The Vatican ought to let us do that. And Father Boyle said, absolutely, 100% not. We're not going to do that. By the way, one thing I did want to say about when I was talking, I forgot, about the items in the Vatican, if I can get to it. So we had the sculptures, we have the frescoes, we have all the designs and the coins. But when Dawn and I first represented Father Boyle and we came to Rome to meet with him, another client of ours, and we've talked about this at Lady Margaret Hall, Doris Duke, we'd had dinner with Doris Duke, and she'd told us, oh, she loves Rome. She'd been in Rome as a young girl, and she said, no, when you're going to the Vatican, you should know they have the largest collection of pornographic art in the world. So I said, oh, that's interesting. So Dawn and I came, we met with Father Boyle, we went to dinner. The Irish and the Catholics, many of them like to drink. We had a nice bottle of Italian wine, we had dinner together. And so feeling a little free, I said to Father Boyle, Doris Duke told me that the Vatican has the largest collection of pornographic art in the world. And he said with his twinkly Irish eyes, he said, yes, my dear, I heard that too when I came to the Vatican. And he said, but the answer is there's no discrete collection of pornographic art. And I said, Father Boyle, you're going to do very well in your deposition in this case, because you didn't actually answer my question. There's no door with an X on it where you go through and you see pornographic art. But there are many, many ancient manuscripts which have some very graphic drawings and are quite explicit. So there is some things we might call pornographic, no door marked X that we can go into and see the sex show. So the case, the Southern California businessmen decided they wanted out, and they thought they had grounds for a breach of contract action. So they filed a suit in Los Angeles Superior Court, state court, and we drew a very, very wise and brilliant judge, Judge Florence Marie Cooper. She went from the state court to the federal court. She's died now. I have to say almost everybody in this story is now dead, but she's died too. But she was a wonderful judge, and she loved the case. And the complaint alleged that the Vatican refused to make the collection available for reproduction under the agreement, and that they breached it by not allowing, among other things, wax molds to be made of the art and for the art to be taken off-site. How did Howarth and Smith come into this? Well, a lot of things in law and life are about connections, and law students in the audience, some of the reason you're here tonight is to meet people and get to know people. St. Catherine's master was Lord Alan Bullock at the time. His wife was Nibby, and Dawn and I knew them well because Gillian Peele had introduced us many years before to Alan and Nibby, and we had had many dinners, high table dinners at St. Catherine's. So Father Boyle called St. Catherine's master when he needed a lawyer in Los Angeles and said, "Do you know any lawyers in Los Angeles?" And Alan said, "Well, I do, Dawn and Suzelle." And so Father Boyle called us, and so we had the entree through the Oxford imprimatur, and we became the lawyers for the Vatican. There were many, many rulings of importance in the case, and Dawn is really going to do the heavy lifting on the law, but there were a couple of skirmishes that I think were quite interesting. So the plaintiff's lawyer, who was a former president of the California Bar and someone that Dawn and I knew well, we were on the defense, of course, he wanted to take the deposition of Father Boyle. But in order to do that, the judge required him to go to Rome. The judge said, "I can't compel Father Boyle to come to California. I don't have the jurisdiction. I have the jurisdiction over this case, but I don't have the jurisdiction to compel him to come. I will permit the deposition, but it has to be in Rome." So I and court reporter and the lawyer for the plaintiff and several paralegals all decamped, a videographer, we all decamped to Rome for the week-long deposition of Father Boyle. So I was a fairly young lawyer at the time, and we went in, and we actually did this. We went in through the Swiss guards, the gate, and we went in, and we had a room, and Father Boyle was going to give the deposition, and I had prepared Father Boyle for several days before the deposition and explained, you must always speak truthfully, don't volunteer information, but if you know the answer, please give the answer honestly and thoroughly. And so we sat down, and the videographer started, and the plaintiff's lawyer, sitting across from Father Boyle, started asking questions. And Father Boyle started responding to the questions. And then the plaintiff's lawyer didn't really like the answers that he was getting from Father Boyle. And so he started being more aggressive. And I let that go on for maybe 60 seconds. And I said, "Tom," who was the plaintiff's lawyer, I said, "You and I have not been opposite each other in a case before. And so you don't really know me, but I need to tell you, if you don't lower your voice and act respectfully to Father Boyle, I'm going to terminate this deposition, and we'll go back to Los Angeles and explain to the judge, and I'll show the video. He's going to answer the questions, but you need to be a gentleman about this." So, this is testosterone, and from one side. And so anyway, the lawyer said, "Well, why don't we step out in the hall, Suzelle?" And I said, "Fine, let's step out in the hall." So we stepped out in the hall, and we had a little chat, and we worked it out. I said, just if you'll just calm down, chill out, everything will be fine. And so we were going to go back in the room, and I said, "But Tom, just one thing I want to ask you." I said, "You're Catholic, right?" And he said, "Yes, I'm Catholic." And I said, "Well, I understand about bringing a case and material, worldly goods, but you're going to burn in hell forever." And he went as white as a sheet. And I reached over and I said, Tom, I'm kidding. But it had occurred to him. It definitely occurred to him. So we got through the deposition. Then another ruling of the judge. So the plaintiff's lawyer wanted to go to Rome and do an inventory of everything the Vatican Library owned. This is massive. This is, and I told you, everything is on little pieces of paper. I mean, they have no formal inventory at the time. So we went in for a hearing with the judge, and Judge Cooper said, Ms. Smith, I've read your papers, and of course I agree with you. I can't force the Vatican to open its borders and let the plaintiff's lawyer go in to do an inventory. She said, however, and I'm not saying I would do this, but I'm just thinking out loud, I could strike the answer of the Vatican, which is in my jurisdiction, and what that means is judgment would be entered against the Vatican, and then the plaintiff's lawyer could collect, however they were going to collect. And I said, yes. And she said, no, I'm not saying I would do that. I'm just thinking out loud of the extent of my power. And she said, let me ask you this as a favor, Ms. Smith. She said, would you go call your client and say, the judge in Los Angeles would really appreciate it if the Vatican, on their timetable, they can decide, let them in for 1 hour, 2 hours, off, at night, anything that won't interfere with the Vatican, but the judge would really like the plaintiff's lawyer and his expert to be able to come and do an inventory, because after all, the contract says that this contract is about all items that are owned by the Vatican Library. And she said, but of course, Ms. Smith, you should go too with your expert. And I said, well, would you ask the plaintiff's lawyer, because you're not supposed to talk to counsel when you're in court. You talk through the judge, can't talk directly to the counsel. So I said, Your Honor, would you ask my colleague how long he thinks it would take? He said 5 days, and I said, all right, so just let me be sure I got the terms straight. So the court wants me to ask the Vatican if I and my expert can go to Rome for a week with plaintiff's counsel and his expert and look at all the art in the Vatican. I think I can do that. I think I can make that happen. And Judge Cooper said, well, if it would be useful for the court to go along with counsel, I'm available. I can make that happen. So that's the carrot and the stick. The stick was I can strike the answer. The carrot was this is going to be a great experience for everybody. So we did go to Rome. Dawn went with me, and we had our expert, who he will talk about, Thomas Hoving, who was a director of the Metropolitan Museum of Art. And we spent a wonderful, amazing week in Rome with Tom Hoving giving us private tours as the plaintiff's lawyer and his expert were looking at things from the attic to the basement. But in the Vatican, there's a lot of things that are very valuable and very amazing. There's also a lot of trash. So every nun in Christendom has done a portrait of the Pope. They send them to Rome. They can't throw them away. So they're all there, and every now and again when the nuns of whatever come, they'll go find them and hang the paintings in the Vatican. But Dawn and our favorite was we went, believe it or not, truly, into the basement. And in the basement where the boiler was, where the man who stoked the furnaces, there was this throne, I'll call it, and it had black arms, wooden arms, and amethyst lion eyes, lion heads with amethyst eyes, and lion skins on the chair. And this had been given to the Pope by Idi Amin. So the janitor was sitting in the throne down in the basement. It's an amazing place. It's an amazing place. And on that note, I will let Dawn go into something more serious and tell you about the law of contracts. Thank you.
So this is the key provision from the contract drafted by the Southern California businessmen that granted the exclusive right to reproduce items, et cetera. Now, when I was a law student, I thought, well, I would never have to litigate something like that because there would be a capital R and a cap on the right and the reproduce, and it would be a defined term. because I would have done it right, as I know all the students here would have done it right. But I learned very early on in the practice that you take your case and your facts and your contracts as you find them. And so you will end up litigating things that you would have done quite differently. And this was elegant in its simplicity, but allowed a wide range of interpretation. The Vatican position was, as Suzelle said, no right to a method to reproduce that would harm an object, and you couldn't take them off the premises. So in the law, it's now fairly established, I think most everywhere, certainly in California, the United States, that where you have an uncertain or ambiguous term in a contract, that's a factual matter. Here this case says, because it's from California, for the jury, but for the trier of fact, it might be a judge if the case were here in England. So where there is a language that is uncertain, then that is a factual matter for determination by the trier of fact. Now, I've cut through that and given you in one slide something that took over 200 years to develop. When I taught the class in contracts at the Harvard Law School, we read the cases leading up to this. And there was a great search for a definitive staying within the margins of the contract that the courts engaged in over that 200 years. It was very much like, you know, the genie coming out of the bottle, and the judges push it back down and say, no, you got to stay within the four corners of the contract. Like the game the kids play, the whack-a-mole, where come up here, come up over there, and so forth. But it's very settled now, not only here, but in the United Kingdom. You have in Bright Asset Limited versus Lewis, Lady Justice Arden, who's here tonight. The agreement cannot be abstracted from the admissible factual matrix. The interpretive exercise is a single exercise taking into account the factual matrix. Now that's both law and literature, but in England you also have it said in more standard legal language. Pink Floyd case, expert evidence is admissible regarding trade custom and practice in the music industry. So we have, as Principal Blyth told you, three very distinguished jurists here tonight, Justice Hogan, Justice Mance, Justice Arden, and you will find law students in your practice that once in a while you'll come into contact with one of these, and it's a pleasure when you do get to work with one of these, because these are jurists that are working on the alpine heights of the law. But I have to warn you that there are also the other type. There are those whose favorite phrases are move along, counsel, or judicial discretion. These people who will never catch a glimpse of the footprints of Holmes or Cardozo or Brandeis, but will be forever relegated to the brachiopods of the judiciary in the Paleozoic ooze. Right? I digress. Going back, so we have uncertain language, which opens it up to custom and usage. Custom and usage of words in a certain trade is admissible to explain the terms used in a contract. And in the United States, we have the Uniform Commercial Code. In almost all of the states, maybe except one, uses of trade refers to common practices in the industry. And that can be an industry, cement manufacturing, can be art and museums, and so forth. Expert testimony. That opens the door to expert testimony to explain what custom and usage is. Now, if we think about experts, they're going to prove custom and usage. Who is an expert? It doesn't have to be the greatest expert in the world to be an expert. An expert is simply someone who knows more about the subject than the ordinary lay witness. So you could have an expert in auto mechanics. You can have an expert, here we had in art and art issues and library and museum issues. The expert testifies with an opinion that is not subject to hearsay. Now, we also spend a long time in law school on hearsay, but think about it this way for purposes of understanding the difference with the expert. With the lay witness, the witness will testify about what he's said, what he's done, what he's seen, and he can be cross-examined then on those subjects. But if you allowed the witness to testify about what someone else said that he heard say, then the lawyer can't reach out and cross-examine that person who actually made the statement. So that is an exception that allows the expert to come in, because he's not testifying, he or she is not testifying about things that he saw or did or said. He's testifying about an opinion, and that is an exception to this rule of hearsay. And the way you would cross-examine this expert is to talk about the basis for his opinion, what his background or education was that allowed him to reach that opinion, and probe the basis and the extent of that opinion and his qualifications. So you would have the right to cross-examine, but it wouldn't be on whether you were there, could you really see what happened when you testified about this or that. So this was our expert in the Vatican case. Thomas Hoving was then the head of the Metropolitan Museum in New York. His family owned Tiffany. He brought the King Tut exhibition to the US, and of relevance to our case in particular, he created the museum shop and sales in the museum in New York. Now, Thomas Hoving did not suffer fools lightly. He you didn't want to leave room between you and the microphone, or he'd trample you in getting there. He was a wonderful man, but extremely certain in his opinions. I asked him one time about a certain concept. I said, "How did it come to you?" And he said, "Don," he said, "it came to me in the classical fashion, in the bath." What was I to do with that? I mean, my experience with the bath was limited to, Ogden Nash's little couplet. I test my bath before I sit, and I'm always moved to wonderment that what chills the finger, not a bit, is so frigid on the fundament. But we got along, nonetheless. And as Suzelle said, Thomas Hoving is gone now. Father Boyle is gone now. Our judge, Judge Cooper, is gone. Alan Bullock, Lord Bullock, is gone. So I understand better as I age what Sylvia Plath meant when she wrote that to grow old is to sit at the breakfast table every day with people who have died. But there are some also advantages to growing old. You don't have to hang around with people you don't like. I mean, except family, but you understand. All right, Thomas Hoving's opinion. I wonder, did Einstein digress like this? There we go. So Thomas Hoving's opinions, first the negative part, no touching the surfaces, no physical handling, no wax molds. That was a risk to depreciate the surface of the artifacts, and you were not allowed to remove it from the library. You can see even from his pose there that he was a man who valued his opinion and often didn't think much of others. Oh, here's the here's the head of his book, Making the Mummy's Dance, which was on bringing the King Tut exhibition to the United States for the first time. So he also had the positive opinions. It was reasonable methods. You could photograph. This is the way it was done in the museums. You could make drawings. You could make computer imaging. And then you would have that stamp of approval that Suzelle talked about that says Vatican certifies this is an actual reproduction. Nobody's going to go measure the exact metrics of the statuette or the jewelry. So we had our expert. We went through the depositions, which are the testimony under oath. Our expert did very well. There was lots of publicity about this trial in Los Angeles. The reporters wanted cameras in the courtroom for the trial. We didn't object to that. The judge was giving us very good signals. Our witnesses had come across very well in the deposition. Father Boyle, Thomas Hoving would be our key witnesses. They made excellent presentations. The plaintiff's witnesses were cross-examined by me and Suzelle, were not as impressive. And so we were optimistic about the result. You never guarantee a result in law because while we as lawyers may convince a judge of some things, there are many judges who can convince themselves of anything, right? So you're never 100% certain. We were optimistic, but then, angels and demons, Suzelle.
So, just one more thing on the prepared for trial and ready to go before I get to something about angels and demons. Our judge was giving us very strong signals that we were in good shape. In the United States, as you know, we have juries for virtually all trials, and she was going to let this go to a jury. But she had signaled to us that it was that close to almost not letting it go to a jury in our favor. She said, on balance, we're in the United States, it's a constitutional right, you're going to do a jury trial. But we felt very good about it. And for those of you who don't know about the American system, once a jury makes a decision, the judge always is the last vote. The judge can always look at a jury verdict and say that is irrational or against the weight of the evidence, and then grant a directed verdict. So it's not just that we have juries and nothing else. Our judges have immense power. So we were ready to go to trial, and we were feeling very, very good about it, and the other side was being very unreasonable, and Father Boyle was comfortable with the idea that we would go to trial. I won't say he was embracing it and just thrilled to be in an American courtroom, but he was comfortable because he did not feel that he'd done something wrong, and he wanted to stand up for his own honor. But I would say about 30 days before the trial, I got a call from Father Boyle. We got a call from Father Boyle, and he said, I need you to come to Rome. The Secretary of State wants a presentation on the trial and what we're doing here. So Dawn was in another trial, and so I went to Rome alone and appeared before Cardinal Sodano, who, again, another Italian. You can see this. This is not a picture I took, but it does sort of portray the man's personality. And so I was summoned, but I came to Rome, and Dawn and I would stay at the Hassler Hotel at the top of the Spanish Steps, and I called Father Boyle and said, so I'm here, so what time are we going to go tomorrow to the tribunal? And he said, well, my dear, I'm very sorry, but I'm totally out of favor, and you have to go alone. So I said, okay. So I went alone, and Cardinal Sodano had with him a couple of other cardinals, all in regalia, in this big, impressive. Judges in here, justices and judges, you know your courtrooms are very impressive. It is nothing compared to the tribunal in Rome, trust me. You know, all the gilt and rococo and everything, and all the cardinals dressed, and they were up here and I was down there. And so they were cross-examining me, and I was explaining about the trial. And their bottom line was, there will be no trial. The Vatican cannot go to trial. The Vatican cannot withstand the publicity. This is not going to happen. And I tried to explain the realities of life, that first of all, this was a good case. Second, Father Boyle did nothing wrong in signing the contract. It was a profitable contract that his predecessor, Cardinal Stickler, had told him was a good contract, had authorized him to enter into, and the Vatican was actually making millions of dollars on the contract by this time. And if the contract had been eliminated, remember, the Southern California businessmen paid $4.5 million. That would have to be given back if the contract somehow or another was made to go away. But my best efforts did not prevail in my inquisition with the Vatican cardinals. And their position was that the Vatican wanted no more publicity, and they would do virtually anything. But they were also looking for a scapegoat. And they were looking for a scapegoat that wasn't a cardinal. And the person that was obviously in the line of fire was Father Boyle. And so the position that the Vatican took was Father Boyle, under canon law, did not have the authority to sign the contract. Only the Pope could sign the contract. So you can imagine how questionable that might be, because the Pope doesn't sign every contract in the Vatican, but Father Boyle took the fall, and he was terminated as prefect, and he was sent to a nunnery in Rome where he really died of a broken heart 6 months later. But the position of Howarth and Smith, represented by this Smith, when the Vatican told me that the position that we had to take in the litigation was that Father Boyle did not have the authority to sign the contract, was that that was not consistent with the facts. And sometimes, law students, you have to say hard things. You have to speak truth to power, even if that power is the Vatican. And so I had to say, if you want your counsel to take the position that Father Boyle didn't have the authority to sign the contract, then Howarth and Smith will have to withdraw from the litigation. So we told the Vatican that there were irreconcilable differences, and we did withdraw as counsel. They retained American lawyers who had represented the Catholic Church in Los Angeles, and those lawyers shall I say, were more pliant than Howarth and Smith. And they were willing to put forward this theory, this legal theory, that Father Boyle, who was the prefect of the library, didn't have the authority to actually sign a contract with the Southern California businessman, therefore the contract was void, therefore the Vatican didn't have to honor any of it. Alexander Stilla, when he was investigating the case and everything that happened, said, the Vatican's rough treatment of Father Boyle appeared to be part of a failed legal strategy by new counsel, not Howarth and Smith, to paint him as a rogue priest so it could disown the contracts that he signed. That strategy, and he also interviewed me, and I said to Stilla, which he did print, that was going to be a hard sell, that Father Boyle didn't have the authority to sign the contracts because under United States law and under British law, if the principal, in this case it would be the Vatican, holds out an agent, in this case it would be the prefect of the library, as having the authority to sign contracts with third parties, then you can't later disavow your agent because it's inconvenient. The agent binds the principal. Canon law may be different. Our case was under California law, and that was going to be the law that would prevail in the lawsuit. After all, Father Boyle had arranged all kinds of shows around the world, including at the Library of Congress, and nobody at the Vatican said he doesn't have authority to sign those contracts. And the stores that he opened were right down the hall from the Vatican Museum. And by the way, John Paul, the Pope, used to sneak out to see Father Boyle when he could slip away from the Vatican, from the Italian cardinals, and they would have a little bit of Irish whiskey. And he knew very well what was happening in the Vatican Library. In the end, under other counsel, the Vatican paid almost $9 million to settle the case, to avoid the trial. And it was a trial that we believed could be won if the Vatican had stood behind Father Boyle and not capitulated. The consequences of that strategy for the Vatican was blood was in the water, there were millions of dollars being paid by the Vatican, and new cases were filed, some in Los Angeles, but principally in New York, with similar breach of contract claims against the Vatican. Years of litigation ensued from that, millions of dollars in attorney's fees, and as recently as 2013, which I know has been a while, but remember our case was 1990, 2013 there was still litigation going on in New York with a host of lawyers representing the Vatican. But Father Boyle's legacy was preserved by the academic and the public community, not in small part due to Alexander Stilla and his articles about Father Boyle and his work in the Vatican Library. He, as Stilla said, lost in this controversy inside the Vatican is the fact that Father Boyle, who never personally profited, never took a dollar from any of this, succeeded in fulfilling his grand vision for the Vatican Library. The money that he got under the contract and used, he modernized the library, he increased public access. IBM photographed all the manuscripts and created an online index, which you can still get online. and did joint projects with the Bodleian Library at Oxford. So my call to action, every good speech should have a call to action, is next time you're in Rome, please visit the Vatican Library. You can now do this, and be sure to mention that you've heard about this amazing Oxford-educated priest, Father Leonard Boyle, who did so much to bring the library into the public domain. And I'm going to give it back over to Dawn now, and we're going to see if anybody has any questions before we go get some drinks.
And in this photograph, were we ever that young, but there are 3 LMH graduates in that photograph.
There are. So the 2 little boys are our son Ames, who's here, and our son Charles, and they both went to LMH. So we're bringing the connection back to LMH.
So we have a number of students here tonight, and we're not going to be a long time with questions, but I want to spend 5 minutes, and I told the students that they had the priority on asking the questions tonight. So I want to go to the students, and which one of you would like to ask the first question? Sir, yes.
So my kind of question is away from I'm a PPE student rather than a law student, but it was around the kind of decisions around integrity. And so how, as a law firm or as an individual, how do you kind of weigh up those decisions where your client is leading you down one way and you kind of stand firm in your beliefs the other way? And so where do you kind of bow down to that and say, okay, I'm going to take the client's side, and when do you stand up for what you believe is right in this case?
A very good question, and one that comes up more in dramas than in actual practice, but it does come up from time to time. And one of the things that we tell all our young lawyers is that if you ever allow a client to knowingly misstate something, to give false evidence, take a position that can't be taken, not only is there a moral issue, but you've put your law license on the line because now that client has that information about you, that you allowed that to happen. And so it's something that we're very strict about, that it must be, you either win on the facts and the law, like Einstein would say for a scientist. We take the facts and the law as they are. We're like scientists. We work with those. We don't change them. We don't allow our clients to change them. And in this case, we could not personally go on when they took a position that was inconsistent with everything that had been developed in the case. But a very good question.
But it was a time in our career that we had to withdraw because a client said, you must take this position, which was contrary to the facts as we knew them. So we were forced into that position, and it wasn't a gray area. This was a black or white that we knew about. So
another question from the law students. Yes.
Well, I think as this lecturer has pointed out, the Vatican is a very unique client to have. And I was wondering, have you felt as a representation for the Vatican that they treated you somehow differently than normal clients do, other than the fact that they were, of course, unfamiliar maybe with Father Boyle in the US legal system? How was the communication between...
How was the communication between us and the client? Yeah, well, of course, he did speak a form of English, and so we didn't have that issue, which we do have in some cases. And Father Boyle was very forthcoming about what he'd done and what his position was, and it was supported well by the experts. So it wasn't a situation where there were miscommunications with the client, but that is another thing that's very, very important to get clear and to make sure that, with your clients and with the opposing side, that you've documented exactly what your positions are and what their positions are, because that will be the meat and the bread and butter of the lawsuit. That's a very good question. Another one? Yes.
This question maybe goes more directly to Suzelle, but it seems that as part of this one story, there were maybe 2 parallel cases, one before California courts and then one, in some sense, before the Vatican itself. And those are obviously 2 very different cultural backdrops. And my question then to Suzelle is whether or not there were any particular rhetorical or stylistic choices that you had to make in one forum that you didn't in the other, and how you made those decisions.
It's a wonderful question, and she was the defendant in one of those cases.
So
go ahead.
I was. It was interesting because I was taken aback when I was called in front of the cardinals. I really felt like we were all on track and all was well, and there I was, and all was not well, and I was clearly being called to task. But interestingly, when it became clear that Father Boyle was being thrown under the bus, I said, and by the way, the cardinals all spoke perfect English, so there wasn't any problem communicating because they were Italian cardinals. But so they said, I said, Father Boyle did nothing wrong, and they said, well, we're going to deal with Father Boyle. We know how to deal with people at the Vatican. And I paused and I said, I'm not exactly sure what you're talking about, but if you're talking about excommunication, I think you need to know I'm Episcopalian. True story. So the cardinals all shook their heads.
We've run a bit over, and I know that, like you, my blood alcohol is getting a little low. So at this point, I'm going to turn it back over to the principal, who'll tell you about the rest of the evening. Principal Blyth.
Well, thank you so much. I just invite all of you to join us for drinks in Talbot Hall, which someone will direct me because I haven't found my way around it. It's this way. And thank you all again. I just want to say thanks to...
And dinner to follow.
And dinner in the Watson room, which is just over that way, just directly opposite here, to follow the drinks. So,
And we can continue our discussion at drinks.
Thank you again.
Thank you.